Andrew Leitch, could you describe yourself?
Andrew Leitch, Senior Associate in the London office of Bryan, Leighton, Paisner. I focus exclusively on competition litigation, so claimant and defendant side, cartel cases and abuse of dominance cases.
And Ian?
I'm Ian Thompson, an Associate Director at Economic Insight. I'm an expert economist in the competition space, working across competition litigation and class actions. Current notable cases include Gaussman versus Meta, the Facebook claim that's already been discussed, and various follow-on litigation from the trucks cartel, which everybody will be familiar with.
Yep, and I'm Nils from Hinten-Reed, obviously founder of CEG, Competition Economists Group. We do lots of competition damages cases. To try and keep that short and not avoid talking about cases, let's get on with this. What we're going to cover is try and actually avoid discussing things that you've had for the last 2 days. I know it's difficult, but we'll try. First off, I'd like to discuss with the panel the sort of trends in class action or collective actions in the UK. I then want to go into the pre-CPO very briefly, because everyone seems to cover it, issue and the standard. But more importantly, I think a lot of people haven't really discussed what happens post-CPO. Because a lot of the actions that we are currently seeing that have achieved CPO status, they're now entering that phase. So let's actually recall what needs to happen for a collective action or a class action. And then the lovely issue of pass-on, where we'll discuss some of the developments and some of the issues, and remembering, again, because it's post-CPO, what the regime or what the law is about. So as we have two economists talking about the law, let me just put it in context, we do not simply apply economics from a textbook. It's all within the legal context. So with that, I think the first topic is basically what's going on in the UK actually, because we've heard quite a bit about opt-out class actions from the consumer level. What I see is also some issues coming in where you have firms that are wanting to get collective redress, and the claims are initially brought as opt-out, and one of the things is Forex. And then, not to plug my case that I'm involved in, but others where you're seeing opt-in and opt-out at the merchant level. So to discuss those sort of legal issues, Andrew, could you just tell us about what's going on?
Yeah, thanks, Nils. So yeah, as some of you might be aware, in the UK, the sort of class actions regime as it is now came in around 2015. And I think it's fair to say the vast majority of the cases that have been brought thus far have been sort of opt-out consumer cases. And I think the CAT's made quite clear that if it's a consumer class, the opt-out is basically the way to go. But what's been interesting is when the class really has been including sophisticated parties, which you would typically see bringing their own claims. And that's just exactly as Nils has said on FX as being one example, and the other example being trucks. So you have in FX two competing class actions coming forward, both seeking an opt-out certification. And the CAT in that case refused both applications and invited the claimants to come back on an opt-in basis, to have it certified potentially on that basis. Now, both claimant representatives have appealed that, so that's all sort of pending determination. But one of the things that was really interesting in that case was, as well as all the usual difficulties in quantification of damages, etc., they pointed to other litigation that was on foot concerning FX. There was a case, or is a case being brought by 175 sophisticated investors in London, led by Allianz. And that case is ongoing as a traditional competition litigation, non-collective action, proceeding through the CAT in parallel. And the CAT held that up really as a reason why you don't need opt out, because actually if these sophisticated companies want to bring their own claim, they can. And similar dynamics, although slightly different in trucks, because in trucks what you had was an opt-out claim brought competing in a carriage fight with an opt-in claim. And again, there was issues there about different expert methodologies and reasons why one would be favoured over the other. But one of the reasons for favouring the opt-in was a sort of, I think, a proof of concept that the opt-in action had already gathered 17,500 opt-in claimants by the time it was coming to certification. So therefore, the need for an opt-out action really wasn't there. So I think it would be easy then, I think, to say you have all of these other claims that are opt-out and have been put forward on an opt-out basis for consumers. And then on the business side, it's a lot more difficult, and it might be sort of opt-in rather than opt-out. The sort of anomaly in all of that is you have another case called maritime car carriers, which is actually a business group that has been waved through on an opt-out basis without as much scrutiny as either FX or trucks. So it's difficult to see exact trends right now, but I think it will start to crystallise, I think, as more and more of these applications come through.
I was going to say, for Ian, do you want to?
Yeah. So in terms of trends, I think what's notable is the emergence of claims against technology companies, basically. So there are the claims against cartellists, the follow-on claims following a cartel or another infringement that's been identified by a competition authority. But there's also been a number of claims against obvious large technology companies, and quite often on a standalone basis. And I think that possibly the reason for this is quite clear, because from the funder's perspective, there's a very large customer base, and that's most people in this room will be a customer of a lot of these companies, and therefore the prospect of sort of minimal damages on a per person basis gives rise to a very large aggregate damages, and that can be an appealing trade-off for the funders. So what we have been seeing is a combination of the sort of classic follow-on claims, albeit from a consumer perspective, but also this proliferation of claims in relation to technology companies.
So in terms of technology companies and those particular claims, they are aggregated damages from the perspective of the consumer. But when you come to the merchants or that level, even on those, you are assuming there is pass-on going down or pass-through going down from the developer or the platform down to the consumer. Yes,
in some cases. So in some cases, there is only one level of the supply chain, effectively, that the consumer is engaging with the company, and I suppose that's another sort of appealing factor. There isn't the issue of pass-on in those cases. In other cases, there is, and that will, I imagine, give rise to quite a lot of discussion and debate and whatever else about how to quantify pass-on, which we'll come on to.
Well, we'll come on to it, because part of the thing is, if you actually have kind of the opt-in, you are talking a different principle. That's compensation principle, where economists have to try and work out what the damages or the overcharge really are per claimant. And that causes, that will be the discussion a bit later. So just in terms of the pre-CPO, there's been a lot of discussion. This morning, Merrick's obviously led to a big sea change. In the standard, you've seen many, many cases apart from 4X. What's your view on the legal standards? Is there any evidence that there will be some tightening, or is it simply the way in which people go into the CPO, the cap will, on the edges, think about small changes but nothing else, where everything's likely to go through?
Yeah, I mean, I think the CAT has sort of made clear now that the sort of standard for certification is very low, really akin to surviving a strikeout. I think the surprising thing for those that have followed it from the outset is it's not really how it was envisaged, I think, by the Parliament in the UK when it was set up. I mean, there was sort of the usual debate was had about, are we going to be fostering a crazy US class action culture, as people like to term it? And one of the things that was said was, you're going to have the CAT there as a kind of gatekeeper for these cases, and it's going to make sure that only meritorious ones are actually certified to go through. And I think that has proven really not necessarily to be the case, given the lower standards. So it'll be interesting to see what happens with these cases at trial. But I think another interesting dynamic is, if you're there bringing your claim forward and you're the only game in town for that class action, then the standard is low, and you've been waved through generally. But when a carriage fight comes, you basically don't have to just meet that minimum standard. You have to be better than the other application that's being brought. So before you know it, actually, the sort of minimum work that was required to get through CPO actually does come up to a much higher standard when you're in the competitive sphere.
Ian?
I'd also add, I think the point was raised yesterday. Although the standard might be perceived to be relatively low, again, I think the funding mechanism provides somewhat of discipline, in that funders will have different conversations with different law firms and economists about potential cases, and they'll only back the ones that they think are better than the other ones, and the ones that they think will have a reasonable prospect of success. So there's competition for the claim going forward. And from an economist's perspective, there's also competition in terms of the finance as well, in that there are different funders, and the competition between them, you can, as an economist, I can take some faith that you might get an efficient level of financing costs for these claims.
Well, I'll probably disagree with you. If there's no constraint on finance at the funder level, the level of due diligence may differ drastically. We do a lot of due diligence work, and yet we still see some of the stuff that we told the funder was no good suddenly gets funded 1 month later. Nothing much could have changed in the intervening period.
Yeah, I agree with you, Nils. And there's been a couple of, certainly one case that I remember the firm I was working for at the time turned away because it wasn't going to be good. And then they went somewhere else and the claim failed, basically on the same reasons that they were told first time around. So I agree with that.
So in other words, pre-CPO, or rather up to CPO, we're seeing quite a few claims, quite a few going through. Some of them may not be of particular merit, would be the way in which I put it. I really would like to focus really on the post-CPO, because there hasn't been an awful lot of discussion. So, okay, we're in the world where we have a CPO being granted without talking merits all the time. We'll keep that to one side. But there are issues. Now, Andrew, if we're in the post-CPO, I'm a naive economist. What's my standard of law? Is it the same as the normal litigation process?
Yeah, I think that's a really interesting question. I think, given that we're post-CPO, really it should just be litigation as litigation normally is in these sorts of cases in the English courts. I think one of the key things that's interesting from my perspective is, if you're looking to establish overcharge losses, one of the key elements in the cases that have been litigated thus far in England have been causation as well as just the overcharge calculation. So typically you'll have a cartel that's said to affect an entire market. The parties will go off and instruct intelligent economists like are sitting here with me in the panel. The defendant one will come out at 0, the claimant one will come out at 10, 15, 20% or whatever it is. But it's not really strictly just a battle of the experts when you then get to trial, because there's more to it than that. It's not a case of just saying, here's my regression analysis, please just now give me damages. You have causation arguments that the defendants raise along the lines of, for example, even if there was a market-wide overcharge, these claimants didn't suffer it because they were sophisticated buyers of the cartelised product that had strong buyer power. Maybe the way that they procured the cartelised product was such that they had, say, fixed-term contracts, and maybe the fixed-term contracts were negotiated before the start of the cartel period, etc., all those sort of claimant-specific reasons. And I mean, my firm in London, my team, are just out of a 10-week trial in a non-class action, but one of the first leading trucks claims of Royal Mail and BT against DAF in English courts. And that was a case that involved significant issues concerning causation. You had a huge amount of documentary disclosure of communications between the parties as to the procurement of the trucks and the negotiation process. And at opening submissions at the trial, we had sort of big A1 pieces of paper produced that showed charts showing fixed-term contracts together with when collusion was alleged to have taken place, all said to show that actually this cartel couldn't have affected these claimants. Unashamedly, I was for the claimant in that case. I will tell you that that evidence was completely unconvincing, and I won't be taken into account and told you nothing about the counterfactual, etc., etc. But nevertheless, it was given a lot of airtime by the tribunal. And I think for those that remember a few years back on a case, Britned in the English courts, again, sort of 2016 or so, in that case, a massive amount of weight was put on very specific issues about the negotiation of the cartelised product. That case was a bit different because there was only a single cartelised product, one massive power cable that was said to have been cartelised. But the tribunal, for masses ways through the judgment, was going on about who was involved in the cartel, were they involved in the pricing process and negotiating the price of that particular cable. And it really was heavily influential / decisive on that case as to why overcharge was very low to non-existent. And I think I can't see how those claimant-specific issues of causation are really going to be dealt with in a class-wide basis, certainly not in the level of details as they have been in other cases. So, the answer to that might well be actually a form of sort of rougher justice, where actually parties do come with their experts. They run regression analyses, and you say regression analysis equals damages. But I think that sits quite strangely in circumstances where, if you're a defendant, there are lines of defence that are open to you in a claim that's brought in a non-class setting that are just not available to you at all in the class scenario. And there was a case at the very outset of the collective actions regime in the UK, Gibson and Pride, concerning mobility scooters. And there was a human rights challenge in that case to the class action that had been brought on the basis that the conduct that was giving rise to the claim had taken place before the class actions regime was brought into power, and therefore they were saying it's sort of retrospective effects of this class actions regime. And that challenge was dismissed on the basis that all the class actions regime is a procedural change. It's not actually bringing in anything new by way of claims that can be brought. And I think that conclusion might come under a bit of strain if you find that actually the class action cases are being litigated substantively very differently from ordinary litigation.
The way in which I think about causation, or this litigation process anyway, post-CPO, is, you have the fact of overcharge, and then you've got to get the fact of overcharge before you start quantifying it. I know economists, we'd like to press the return button, but you actually have to do the work saying whether the allegations could have led plausibly to harm. And equally, the symmetry is on the pass-on. A lot of the discussion, we'll come onto it, is actually press the return key without thinking about, is actually there a factual base for the firm? And I think this morning they were discussing the economics, and I think one of the things that came out of it was, hold on, just wait before you start pressing the return key, because you actually have to have the factual base of how firms price. Now, just coming to the point about defense, I think it's interesting, when you talk about a class or a market-wide, that's the kind of the liability. Some of the defenses, to the extent that, certainly for pass-on, you will not be, and for an opt-in, you're not going to have 10,000 assessments. You're going to have to think about what is common across, or give some examples. So if you're thinking on the pass-on side, but on the liability side, why can't you come up with examples where people would say, well, let's test the defense?
You mean examples of scenarios in which it could have been passed on? From people in the
No, but not
past?
passed on. I mean, actual, defense of buyer power.
Yes.
So is the buyer power relevant in this particular industry?
Oh, I see. Well, I think it's quite tricky because the issues that we're talking about here really are quite claimant specific. I mean, I don't think you would necessarily say, unless you want to take broad brush assumptions to say, actually, companies that have over an X amount of market share or revenue are necessarily sophisticated purchasers that, drove hard buyer power and therefore their damages should be reduced. You can make those sort of broad brush assessments, but that's not how it works in regular litigation. In regular litigation on this stuff, these are litigated issues involving evidence, not assumptions.
So Ian, I'd like you to sort of explain sort of issues you typically get post-CPO for a collective action or class action.
Yeah, indeed. So I suppose one obvious difference is that for an opt-out collective action, what we're aiming for is aggregate damages. So we've got the beauty in a way of not having to consider each individual person or entity individually. However, they need to be common enough for them to form a class. So there can be a bit of a tension there. But supposing that it has cleared the CPO stage, the CAT is sufficiently confident that the issues that are being considered are common across the class. And that commonality doesn't mean that the effect of the infringement has been the same on everybody. It can be that there are different entities that have different characteristics, or indeed have purchased different amounts, different volumes of whatever the product has been. So in terms of how to go about the quantification, I think the start point would be to look at the class in the round and to consider whether an aggregate model is a robust model. And it can be that for any one individual. It's not a perfect model, and indeed every model is imperfect. But if you're able to calculate a robust average estimate of overcharge, for example, multiplied by the number of class members, will give you also a robust estimate of the aggregate damages. So that's broadly how I'd start. If there are good reasons that an aggregate model won't give rise to a robust estimate of aggregate damages because there is variation across the class, then obviously that will need to be taken into account, and that shouldn't be shied away from by the economists. But it should very much be driven by the facts of, are the class members different? And then also, would you expect from theory and economic principles that an aggregate model wouldn't be the right one?
Right, so I mean, we're thinking of an aggregate model for, say, interchange may be totally different from saying a cartel on copper tubes across different uses, or the Google, I think, example yesterday where I saw, okay, that was pass-through, but that differed quite radically according to whether you're dating or some of the other uses of the Google Play Store.
Yeah, indeed.
Okay, so rapidly moving on, because I would actually like to get to pass on. Because if we talk about post-CPO, and we talked about the regime, well, we're doing litigation, okay? Pure litigation. When pass on in the UK, there was the Sainsbury's judgment in 2020 versus MasterCard, where pass on was defined in terms of 4 different avenues. And now, within the collective regime, we're seeing a bit of a debate in terms of the CAT thinking how in effect to case manage what I think are 500 or maybe 1,500 or I don't know how many individual claims by hotels, and then the collective actions, one of them being Merrick's, the other one being the new commercial card, pre-CPOs. So once sort of get into debate, what's your view on where we're going? I mean, how consistent is what is being proposed by the CAT now with what in effect is the UK pass-on law, as emphasised by the Supreme Court?
Yeah, so the Supreme Court gave us our seminal judgment in the MasterCard cases about what constitutes pass-on, what the legal test is for pass-on mitigation. And in addition to sort of four avenues, four ways in which a company can react to an overcharge. For those that don't know, in brief, so the first is that a company can basically just suck it up and suffer a profit margin decline as a result. Second one is that it can reduce sort of discretionary expenditure on marketing or whatever else. Third is that it can negotiate prices with its suppliers down, so as to sort of offset loss that way. And fourth is to sort of, as we know it, classic pass-on, raise its prices and pass it on to its own customers. And I think most importantly for me is actually the other aspect of it, which was the Supreme Court found that it's a subset of mitigation pass-on, and therefore the ordinary common law rules of mitigation apply to it. And the key thing being, under the sort of British Westinghouse test case from a very long time ago, that there's got to be a sufficiently close causal connection, in this case between the overcharge and a price increase. And I think some of the difficulties that we're going to see in class actions and pass-on in the UK is really down to the state, really, of the law on pass-on in the UK. And by that I mean there's been no effort at all by the UK judiciary to actually narrow the scope of pass-on in any way. Quite the contrary, they've taken a very expansive view to what it might involve. So I remember doing these cases, best part of 10 years ago, when pass-on seemed a lot simpler. You had industrial manufacturing cartels. To take an old example of a case I worked on, you had a cartel at the level of manufacturing cathode ray tubes, which for anybody young enough not to know what that is, it's basically the glass bit that went in an old school television or computer monitor. And you'd have a situation where the cartel with that level of supply chain, they would sell them down to a computer or television monitor manufacturer, they would incorporate it into their product, and that would then be sold down the supply chain. And the issue is simply on that incorporation how much has been passed on. So that's, I would say, the sort of properly classic pass-on. Then you have a sort of next one along the spectrum, and that was a good example of that is the Royal Mail and BT Trucks case I was just discussing a moment ago, where you basically have an argument that because Royal Mail and BT paid more for trucks, actually when you look at all of the regulation applying to their pricing and everything else, this overcharge on trucks eventually wound its way through to like an extra penny in your Christmas stamps, or an extra couple of pennies in your international phone calls that BT charge you for. So you've basically got pass on through a completely unrelated product. And then further still, in this most recent interchange judgment that came out on pass on, the CAT mused about potentially pass on through a company having suffered the overcharge and then lowering the wages of its employees or cutting some employees from its workforce, and that being the pass-on, and those workers having the claim against the cartelists for having their wages cut. So where you have pass-on in such a wide way, it becomes very difficult to see how you're going to manage this when you get to a trial in a collective action on a class-wide basis with all of this still very much in play. The answer to that, I suspect we might end up similarly in the way that you might with overcharge, in having effectively an expert-led process, which is what the CAT indicated in the latest judgment, where you might just have regression analyses competing to get you the outcome and the result. And I think I'm not going to do that down as an approach really on its own merits, because you need to find some workable way of making this regime work, and you can't just hold it to such a sort of perfected standard that nothing works. But similarly to the issues of causation that I was discussing, this pass-on issue is usually one of quite significant factual evidence in regular litigation. So the legal test, to remind you, is that there's got to be a sufficient causal connection between an overcharge and a price increase. So how you can basically run some sort of high-level analysis on a regression analysis and say across the piece for a claimant class that sort of test is met, I don't know. And I think if you might be, it's another form of rough justice, and that rough justice might be sort of, you might feel less aggrieved by that if you were in that cathode ray tube example that I gave. You might recognise, okay, fair enough, you can reduce my damages at a high-level basis by 40, 50%, because I recognise that that's probably right enough. But I think if you're going to knock off 20 or 30% of my damages because I might have lowered my worker wages or laid off some employees, I think I'd feel pretty aggrieved as a claimant in that circumstance.
Maybe I'll take you a bit of a step back. Sainsbury's versus MasterCard, I was the expert for Sainsbury's. So in actual fact, the Supreme Court came up with the approach, but actually this wasn't really contested on appeal. The fact of no pass-on was something that wasn't actually appealed. Now, the point here is it's actually a burden of proof point. And the burden of proof was we had immense disclosure, immense. Literally, I think I had the whole of Sainsbury's on my laptop. It's great. Economists, we have all this data. We couldn't prove anything. We could not prove the causal link between an operating cost called interchange and the price of baked beans. And we couldn't do it any other way. We actually took on the evidentiary burden and still didn't achieve that. Now, the point is actually the burden, as you lawyers out there know, is actually on the defendants. Now, there is something that the CAS has done, is actually come up with an umbrella order or procedure where we're going to think about these things. And he suggested, rather than, because the idea is this case management, it's very difficult to see how you can do, as you've said, 500 individual assessments a la Sainsbury's versus something called econometrics. It's not actually doing econometrics, but actually doing a survey, in effect, of previous results. We'll come on to that. But it's never, one of the trade-offs is to what extent you're looking across the market. If you know that pass-on is basically, in terms of pricing, cost plus, a lot of industry, a lot of the merchants actually don't do cost plus. You can say that, so to what extent can you narrow down the actual issue to certain specific, so you're not talking about 500 individual test cases, but actually a much smaller number, is an issue that's going to come up.
Right.
And there's an interesting hearing that's going to be, I think in May next year, where these sort of issues come up. But I'd just like to, reminding that, if you can't prove it, then it's zero. Versus econometric studies which are basically not about an operating cost, but they're actually about the input, the baked beans. So if you can't tell a baked beans, that's what the pass-on studies say, and they can be anything. It can be 0 or can be 130%. That's the range. So I just want to hand over now to Ian, the difficult task of how do we go about this, and can we do econometrics consistent with the Supreme Court? Because there's, as I would say, those previous econometric studies are not on the basis of the Supreme Court test. Ian, over to you.
Thank you. I'll go back to these four routes through which pass-on can happen in the first instance. And from a layperson perspective, I think they're reasonably understandable and you can envisage them. The firm might do nothing in the face of an overcharge. The firm might increase its prices given an overcharge. The firm might realise it's facing a higher cost here and therefore negotiate more somewhere else. Or it might decide simply not to do something, not to engage in in a marketing campaign. From an economist's perspective, setting aside the theory of all of them for one moment, demonstrating and proving any one of those is a very, very challenging task. So I suppose from our perspective, if the law is more specific, which I think the Supreme Court was going down, that provides some certainty that we only need to look at certain effects, provide certainty for claimants, for defendants, for everybody else involved. But nevertheless, if these effects have arisen, I'm not quite sure how that sits with the principle of compensating for harm that has been caused. So I think there's a trade-off with the tightness of the definition. It looks like the Supreme Court has made a decision, and the CAT is not quite sure about how to interpret it. But then once we do get into how do we quantify these things, obviously there's various options. Again, I would suggest that the best place to start is the facts and what the simple principles say about each of these potential avenues. And from a sort of economics 101 perspective, the notion of reducing a cost over here in light of a overcharge somewhere else sits very uncomfortably. Why didn't the firm do that before if it can negotiate a lower price? Why would it not negotiate a lower price on a completely unrelated input? There may be reasons why such an effect would arise if there are margins that are being targeted or something like that. It's always 10%, and if something goes up here, then something else has to go on somewhere else. But that's quite a imaginative, creative reason for such an effect to arise. So it may be that from an economics and a factual perspective, we can start narrowing these avenues down. Then I suppose based on the set of avenues which we think are plausible, one approach would be to look at it at the aggregate level, to look at the profitability of the firm. All of these avenues, the three avenues that involve doing something, are mitigations to an overcharge or to an increased cost. And therefore, if all else equal, if this cost increase has been fully mitigated, you wouldn't see any change in profitability, irrespective of which channel it comes through. So one approach would be to step back and consider the everything in totality from the aggregate position. Alternatively, we can look at these things individually. Separate econometric models could be built for each avenue, for example. Simulation models could be built. They're heavily dependent on assumptions that may require less input data, and can, if they're kept simple, be understandable and comprehensible and don't turn into a black box. Alternatively, we can rely on previous studies, a literature review almost. The question over extrapolation will always come up. Is there a study that happens to look at the precise product over a similar enough time frame that is a similar enough order of magnitude of cost? As I've said, there are various options, and which option is taken should be assessed on a case-by-case basis based on the facts and the theory that apply in that case.
I mean, is it the case that, in effect, I sometimes get the feeling that we have all these cases. They're not the ideal case to create a precedent. the wrong cases get before the Supreme Court, and then we start working out that it isn't actually the right precedent for other cases. That, you know, if we're talking about a baked beans cartel, it may be quite a bit more appropriate to then say, well, we roughly know what the implication is.
Yeah, hard cases make bad law. The old
hard cases
saying.
make bad law.
That's right.
And, you know, the exceptions to the rule, the ones where you have costs are fixed, essentially, we're litigating.
Right.
And these are the ones that, you know, are creating the need for a procedure. Because we're on the continent, and, you know, I did my Brexit 25 years ago, the other way around, I just actually want to discuss something that came out of the ECJ the CJAU last week. And actually it's trucks, but it's an interesting issue on disclosure. You know, we have lots of disclosure when we do cases in the UK. Part of the problem maybe with the whole UK regime is you have too much disclosure and it's too costly. But it is something that can be expert-led in terms of determining what, as an expert, you really want to see to do the analysis you want to do. Whereas I've done a lot of cases in the Netherlands or Germany where, you know, to the extent there is disclosure, you have to actually had to know exactly what was wanted, the actual document, even down to the name. And then you had the variables, you know, in Germany, basically you weren't allowed it. In the Netherlands, we've had a few instances. And this judgment, Picard, do you want to actually just give an outline of what happened last week?
Yeah, I mean, yeah,
from a UK perspective?
Well, yeah. I mean, it was a sort of preliminary issue reference to the ECJ, and I think the thing that's grabbed the headlines on it, it's obviously this is sort of the first disclosure applications arising following the Damages Directive, which opened up disclosure in a lot of jurisdictions that didn't previously have it, and this one came out of Spain in Barcelona. And the thing that grabbed the headlines on it was that it held that you could have, as part of relevant documents to be disclosed, documents that effectively had to be compiled or created for the purposes of the litigation. So if there was sort of materials that you were looking for, you know, they didn't necessarily need to be strictly pre-existing documents. And I think it's interesting. I don't find it particularly shocking. I think in the UK we've had that for a while. I mean, typically in the UK disclosure is of pre-existing documents, but certainly in the CAT, in cases I've been involved in recent years, they have asked for, you know, statements to be produced explaining how certain things worked as an alternative to disclosure being provided. And I think there's advantages and disadvantages to it. I think, you know, in terms of the impact on that judgment for litigation in the EU, I think where you can use that sort of compiling of information which is relevant and get that produced for the litigation, if that is sort of as an alternative to voluminous trucks full of documents to basically document dump and give you everything, then yes, it's going to be much more cost effective and sensible to just get that compiled data set. I think unfortunately what we've done in the UK is we've done both. You basically get the document dump from the truck and you then get this separate stuff that's been compiled. But the word of warning that I would say as well is, not that anybody breaches their duties or anything else, but if somebody is compiling data for you, the advantage of pre-existing documents is that they're inherently truthful. They're what happened at the time. Whereas as soon as you start compiling data and selectively putting things forward in a way that you're taking a judgment as to what's relevant, I think the sort of scope for gerrymandering there and things not being quite what they were at the time is...
Yeah, I mean, but to what extent? I mean, I've been on the defence side in the Netherlands where you've got claims that basically said, and usually you have to be upfront about what your claim is, and they said, well, we don't have disclosure, but we do have an Oxera report that says it's 18%. The implication I have would be on the overcharge that sort of claim should not be made anymore. You know, you've got enough evidence or ability to get disclosure now in a certain form that for a defence side, for the overcharge, you should actually come up with a better estimate. And on pass-on, if the answer is, well, we have no disclosure, so we can't do a pass-on defence, equally, for the defendants, sorry, you can ask for a few things. So, it's an interesting, we've heard some defence side counsel here over the past few days, it seems this hasn't really filtered through, that it may actually change things. Not saying it's going to be UK litigation, but it may mean that experts actually, if they want information, the good thing is they actually have to say why and what for.
That's right. If you can get it at a pre-action stage, then it does help you at that
And that's
time.
the issue.
I think that's the issue. It's the timing of it. The reason that the Auxiliary report is known and loved and is sort of equivalent to tablets of stone in Old Testament in litigation for claimants is because it gives you a number to put in your claim when you bring it, and you don't want to spend a whole lot of money on a sort of partial analyses at the outset before disclosure takes place, to then have to redo all the work once you actually get the documents. So I think the timing piece is a big one. How early are you going to get those documents?
And an assumption like that can be particularly helpful when we're considering class actions when, for example, it's a consumer class action and there is no evidence, there is no disclosure, and effectively an assumption needs to be made, whether it's the average overcharge for whatever or another broad brush approach. Those approaches do need to be taken.
That's if you can do a placeholder. If you're actually in a jurisdiction where you actually have to come up with the analysis up front, question whether that's going to be enough.
Yeah. I think in general, from an economist's perspective, we want more rather than less data, and if it can be the curated data set that provides what we need rather than a download from some database that's 20 years old and is a pain to put together, and I can see the appeal from the practitioner perspective.
And at least one assumption, we do assume that lawyers actually do follow bar rules.
Yeah.
Okay, I think that's enough for us before the drinks, but are there any questions at all? Or do we have to...
There's one over here.
Could you state who you are and...
David Green from London. Is this working? Yes, that's working.
Oh, great.
Yeah, David Green from London. I just wondered about disputes on the claimant side, as a claimant lawyer, we've talked about carriage disputes, but also, presumably, we're going to see quite a lot of vertical market disputes on pass-on and pass-through.
Yeah.
And with, in a way, those in the vertical market arguing amongst themselves as to where the loss actually lies. And I just wonder how we see that developing. I was thinking of Amazon, particularly the claims against Amazon, particularly in which you've got consumers, but you've also got merchants, perhaps other markets in which you'll see that vertical debate going on. And I just wonder how that's going to resolve itself. How does the court address those issues? Is determination of the merchants pass on binding then on the consumers, or the other way around, and how the court's likely to address that issue?
Yeah. I mean, that's I think is sort of the thinking behind this new umbrella proceedings order that the CAT's put out. And that's basically a mechanism whereby claims that arise out of the same wrongdoing. So the one that's been done is in relation to interchange, and there's been a whole load of claims that have been subject to this order. And some are collective actions, well, one collective action from Merrick's and others that are not. And you do have there the sort of two layers of the supply chain. You've got the consumers represented by Mr. Merrick's, and then you have a whole load of sort of retailers in the middle. And the idea, I think, is that they're going to effectively determine pass-on across the supply chain at one single hearing and determination, and that is going to be binding. I think that sounds sensible at first blush. However, there's trade-offs in doing that. I mean, I think, for a start, if you have limited overlap like you do in interchange, because although that sounds great, like you've got the consumers and then you've got the retailers, actually there's different time periods covered by the claims such that there's not actually really any particular overlap in that case. Nevertheless, they're trying to use those two layers of the supply chain, I think, to get the framework for what pass on is going to be in claims that are ongoing and are to be brought. But I think it's tricky. If you had a class action covering the entire merchants sort of level, and you had another class action from Mr. Merrick's one for consumers, then I think that might make sense. You have that one determination and you get a sort of market-wide at least average. But where you have only a subset of one of the classes bringing it, it's not really inconsistent to say that actually, you know, there was a whole lot of pass on to consumers, but no pass on from those particular retailers, because those particular retailers only make up a very small amount of the merchant class. So I don't, you know, for me, they're really shoehorning some of this stuff in at vast time and expense, because although it sounds like an interesting and useful thing to do, the reality of it is, especially in the UK, the costs and time of actually going to these hearings, preparing for them, is adding millions onto legal budgets. So unless you're really going to get something really useful out of that by way of a determination, I think the parties would probably rather just get on with litigating against the defendants.
I was going to say the ideal would be, you know, collective at the merchant level, and collective at the retail, at the consumer level. I'm not quite sure. You know, there is an issue about time periods.
Yeah.
But really, whether the actual overcharge and how it manifests itself and how it's passed on is time variant should be tested. Because I don't believe actually in that particular case, lessons from late 2010 will be any different in 2015 or 2020. Not to a great degree. So if we're applying the broad axe, you know, the cat can sort it out.
Yeah.
We got one more question than most people. That's it for me.